stage. Hey! Why the hell has it got me way up there? Oh, that's better. There we go. I think that works. I'm trying a new camera and setup and lighting setup. I don't know if the lighting's any better. Okay, I'm not happy anymore. And I did such a man, that freaking video I did was awesome. It was the best one I've done. I was so happy. I loaded it, and thank y'all. I thank y'all, whoever the two of you that responded saying, "Hey, bro, I got no audio because I'm a moron." This is what happens if you let a moron try to mess around. This is what happens. Yeah, I apologize. Um, I'm gonna take my sorry face off of here, and I'm just gonna try to get this way under an hour. I'd like to do 40 minutes, but so I may skip a little bit over stuff. I'm not going to be as I'm tired too. I did it like several hours ago. I was like, oh man, I was so mad. It took me a few hours to get back into it. I'm going to I'm not going to gloss over it, but I'm going to gloss over more of the stuff than I did the last time when I did the quiet video. It makes me mad. God, man, it makes me mad. Man, that's what happens when you're a perfectionist or whatever. It happens. Don't try to do that on the bar exam, folks. You will disappoint yourself miserably because no one's perfect. These people, they're like, oh, I scored a 280. Bullshit. They tell you when you take the bar prep courses, oh, you're only going to make about 55, 60%, but that's okay because you're going to get a curve, and the curve's it's going to bring you right up over the two. Well, it used to be when I took it, it was 256. I think in some states now, because of the stupid ass, God, silly ass, dumb, freaking multi-state, I'm sorry, universal bar exam, which I took. It's supposed to be some awesome equalizing bar exam, and oh, it's going to be the same everywhere. Bullshit. Freaking maybe the same test that you're taking everywhere. It does not give you a license in every state. You freaking still have to make over a 270 to transfer your score first 2 years. After that, you're done. You're going to wait until usually it's 5 years of practice full time. Then you can motion in without an examination to another state. I've done it, but that takes, I think they'll usually say like either 5 of the last 7 years or 3 of the last 5 full-time practice have to be practicing for 5 years. 3 of those have to be full-time. You got to have reciprocity. Some places want the score to still be a 270, which is getting up there, man. I mean, I think I don't know what asshole graded my test, but I'd love to kick and just squat in the nuts. Because I got a 269.4. How do you get a 0.4? Who does that? And I didn't get a curve. I took the first UBE in Alabama, and we blew the curve. Blew it. So instead of a 1.2, you take your raw score. Let's say you did a 251. 251 times 1.2. That'll give you your final passing grade score, which is they don't ever take your cold score. You can find your cold score. It's a little of a pain, but so I think I got, I don't remember. It was a 269.4. I only needed a 256. And a lot of states are upping it to the point now, and they don't tell you, where it's like, oh, we want a 270 out the gate first time taking it. That's not an easy score. Chat, that ain't easy. I'm telling you. It's a bullshit exam. I think as long as you graduate from a state approved law school, because I didn't go to an ABA school. Fuck the ABA. The American Association of Law School is the oldest one in the nation, and the ABA is a criminal organization set up to literally run it in every damn state. Oh, you got to have ABA accreditation. Well, that cost $1 million alone for the licensing for the year, not to mention the bullshit that they put on schools such as, oh, I don't know. Let's see. Your law professors, oh, they have to make at least $150 a year. Oh, that's okay. We'll just charge more. your library. Go to a law school. Look at their library. See how big and expansive it is. Not all of them. They're allowing a lot of them to shrink them and put them on electronic media. You go to the University of Alabama, which is a top 20 law school, has been since, oh God, the 90s. University of Georgia, too. It's a ginormous library. They have the statutes for every state of the union, and I think some of the territories. Uh, you don't need that. You're only taking the bar exam one time. Well, let me rephrase that. Some people are gluttons. They'll take it more than once. You're taking it once. Okay. You might take it two. You might, if you don't pass it, or you might take another state. Who knows? Um, which is a nightmare. I can't even imagine. Oh, God. I'd rather jump off a cliff with no parachute. Um, anyway, so they have all these rules, the ABA, and it's out of Chicago. Great place to. Oh, that's fantastic. That doesn't scream corruption, does it? No. It's a corrupt group. Okay. And so, unless you go, it's so fucking stupid. I hate the bar exam is a scam. If you go to a state approved law school, there are some still around. This is not including California. Freaking A. Don't even include that. Because they have so many online schools, they have a different bar exam. They just have different stuff on it. It's done different. It's just different. They don't even have the universal bar exam there. Them and I think Georgia still hasn't. Florida don't, and I know Louisiana has. They just have their own. It's Napoleonic civil law. It's just different. Um, that's really the only argument I can see. Like, well, I went to I don't know law school in Louisiana. I'd like to move my practice from Louisiana to Tennessee. And it's like, no, no, you have Napoleonic code, and Tennessee is English common law. The two do not mix. You should have gone to the other side of the law school, which was English common law. It's a nightmare. Um, anyway, the point about the stupid bar, you should be able to take the damn bar exam. If you have a freaking state approved law school, freaking state approved, meaning the legislature says this is good enough for us. Boom, rubber stamp. You have that in Alabama, Birmingham School of Law, unfortunately, Miles School of Law, which is just running as an economic scam for historical black colleges and students. Most of their students just bail and go to Birmingham School of Law. It's bad. Their passage rate is in the, I think, 1.5%. You're just stealing money. Screw you, you're stealing money of people. And these people work. They're all at, I mean, they're all, the 20s, 30s, 40s, 50s trying to go to school at 9. No, just no. But anyway, those Faulkner and Montgomery used to be that. Now it's ABA. They went from like, here's a good example. In the 90s, Woodrow Wilson College of Law in Atlanta, Georgia. It's now Georgia State College of Law. All right. Went from non-ABA to ABA. Literally, the year it switched. It went from 10,000 a year in tuition to 30,000 a year. Let that sink in a damn bit. You're going to spend over 6 figures and come out of law school and not be able to get your head out of your ass to get a job. Because why? There's a million other maggots on the field are looking for the same piece of rotten meat. It's not enough. There's just not enough work. There's too many of us. But if you take, damn it, people won't quit texting me. Damn it, leave me alone. If you pass the damn bar exam, here's how it should work. You go to a state-approved law school, state of Alabama. Tennessee has National School of Law, which operates like Birmingham School of Law. But you can't go between those two either. Let's say you go to National School of Law and go, oh, man, this is just like they do in Alabama. It's Birmingham School of Law. I'll just take the bar there. I want to move there. No. They still have the dumbass rule of ABA unless you fit these other options. And Tennessee, vice versa. And then they don't tell you when you get in and you spend $1,800 for your license, whether or not they're going to fuck you in the end with no lube. And what do I mean by that? Oh, Chris, you might be asking, Chris, what do you mean? I mean this. You spend all that money. You still don't know whether they're going to accept you or deny you. You have no clue. They may say, hey, Dad, you can take the bar. You're like, I just took the bar. I took it 5 years ago. I took 7 years ago. Well, you can take it again. Then you get a license. You say, no, I want to motion in. I'm sorry, no, you didn't go to an ABA school. What difference does it make? My law school is not ABA. It's approved by a state adjoining your state. And you're saying I can't motion in? And we have reciprocity, which is where one state bar and another agrees that they can swap. Eh, That's simplistic. Uh, this is the scam they don't tell you. So you got to go ABA. And unfortunately, they're right. But the problem is, damn, you're going to spend 120,000 just for tuition on law school. Let us sink in. 6+ figures for a freaking lot. First off, 3 years is a joke. It should be 2 years. Well, my cousin, who was, I gave you a little family history. I don't want to give too much of a history so that people know exactly who I am. Well, damn. Um, he just passed away a couple years ago at the ripe age of 91. He was snuffed in the prime of his life, as my uncle would say. Um, he went to law school at Alabama in the 60s. He had a very, um, I may say it one day, I don't know. Let's just say he knew Bear Bryant. Um, and anyway, he didn't have, he went 2 years. He had 2 years of undergrad. Richard Shelby was senator of Alabama. He went to Birmingham School of Law. I guess he couldn't pass the damn bar exam because we were the only ones required to take it in the 60s, that era, 60s, 70s era. And then they started making everyone do it. But at that time, my cousin went, you went to the University of Alabama, you graduated, you were a member of the bar. You were a lawyer. So I'm guessing Shelby couldn't get past the damn bar, went to UA, finished there, and became a bar member. Uh, that was just the way you had to do it. But it used to be that even Birmingham School of Law wasn't 3 years. You didn't have Juris Doctorate. And I know I'm going on a rant. Damn it, I'm tired of it. And I'm pissed off because I read some stuff earlier that made me mad. Damn it, I'm tired of it. You only needed 2 years of law school. 2. You freaking went to school for 2 damn years, college. Said, thank you. I appreciate it for my freshman and sophomore year. I'm going to law school. Hustle, bye-bye. You applied, went to law school, did your 2 years, and you got what was called an LLB, letters of law baccalaureate. Take the bar exam. Or if you were lucky and went to the University of Alabama, just start practicing law. My cousin used to joke, he's like, hell, I could never pass a goddamn bar exam if I had to. He said, hell, I've never been a lawyer. And he was a good lawyer. But that's how it used to be. That's what it should be. You should be 2 years for law school. I can teach you everything you need to know to be a lawyer in 2 years. But the ABA started this bullshit of, we need a doctorate. A doctorate. We need to be just like medical doctors. No, we don't. Little different. One puts their freaking hands inside a human body while it's still operational to save a life. We read shit and write shit and argue. Yes, we can be of benefit, but it doesn't take that many years of education. It's a scam. I don't need a 4-year degree and 3 years of college. No, I don't. So that's my little soapbox. The ABA can suck it. If you really, really, really want to make sure you can practice in another state after you've taken a bar or whatever when you get older, because trust me, you'd be surprised, dude. I never thought I would be in 3 states. It's been a nightmare. If that's what you want, you better go to an ABA school. If you're not, I don't think there's that many state approved law schools anymore. Texas Bar has a great rule. It says American Bar Association school or a state approved, or it may say state certified, whichever, law school, which for in Alabama, if you read the statute, it's literally statutory. It operates upon basically the foundational educational point of University of Alabama School of Law, and then they add a year to it just because they can. They didn't used to. In the 60s, it was 2 years as well. It was 2 years, but you had to have 2 years of college. That was the thing. Long time ago, you just had 2 years of law school. You come right out of high school, they didn't give a shit. Things have changed, and I'm not sure it's for the better. It's just causing debt. All right, I'm done. I ain't going to talk about it no more. If you want to know about it, you want an episode about bitching about law school and the realities of it, how it's going to ruin your life, potentially, please just comment or let me know. I'd really appreciate it because honestly, it's an area that uh, as you can see, I'm pretty hyper about, and um, I feel strongly about it. So, um, and it's an area too that I think screws a lot of people. It ruins a lot of lives. Um, when they come out of school and you're in debt, let's just say, shit, I don't even know anymore what undergrad would cost you. Let's just say 100,000 for law school plus another 160, 180. Dude, you better come out. You're gonna come out, and you know what they're going to pay you? I'm not kidding. 50, 55,000 a year. Hell, you gonna do with that? You couldn't live on ramen noodles at all. Within 5 years, if you're successful in any way, yeah, you probably make six figures. Yeah, you probably pull a little over 100. Yeah, sure. The government takes 30%. Now you got all the loans to pay. You're fucked. I'm not, I hate to cuss, but there is no other word that covers it in the English lexicon than you're fucked. That's it. So let's see how bad this dipshit. I hate Alec Baldwin. In case y'all didn't know already, I think he's an arrogant, narcissist asshole. Let's go over his silly ass, stupid suit. Well, shit. Now I need to figure out how to. Let me increase the size here. Oh, does that work? I don't like that. Hang on a second. Let me see if I can't. I'm trying to be able to see both sides. I don't have two screens, which kind of sucks. That probably should have. Uh, Probably. I've got an iMac that I'm using. I think it's like 7 years old. It's out of date, and I'm running a hacked version of Sequoia, so it works. It seems to be fine, but I can't get it to uh, mirror the screen or extend the screen using my MacBook. And it's new. That's an M1, so it's not the problem. Um, so I only have one screen, so forgive me. It's a pain in the ass. I hate it, but it is what it is. I'm not going to spend money. That's the other thing. Don't go spending money for law school and shit. When you get done and you pass the bar, dude, ramen noodle that stuff. And don't run an office. You don't need an office. Meet people at McDonald's. Meet them at their job. Don't go to their home. That could be bad. You know, do it on rent a virtual. Perfect. Rent a freaking virtual office. That's what I should have done. Perfect. You pay, I don't know, $100 a month, 1,200 a year. You got an office. Nobody knows any better, but you've got an office. They can't just drop by, but you got an office, or at least have a conference room. That's really all you need. Freaking take your butt home and start working. That's the reality. No one's going to tell you this. I'd be shocked if anybody texted me and said, "Well, that's something new I hadn't already heard." No, nobody told me, and I looked and begged and pleaded and tried to get. I got nowhere. Nobody cared. Nobody cared. So let's go through this first part of oh shoot. This first part of this suit we were doing. I said there was a lot of other stuff. It was like state claims and stuff, like um, state claims. I'm trying to remember. I almost got confused with the damn it, the Fox Sports lawsuit that I did a thing on. Um, that one is shocking. Holy crap, it's shocking. I knew who Skip Bayless was. I just didn't know that. Wow. So if you haven't watched it, please go watch it. I'll try to put a link at the end to go. Wow. Now I'm not done with it either. It's just wow. But we're going to cover what I think is mainly their issues with this suit. Okay, they're as I talked about at the beginning of the first video, they're trying to shoehorn. I don't know why. It doesn't make any sense to me. I'm just a dumb Alabama lawyer, and this shit definitely don't make no sense. And I don't know why no one's called it, because I've watched several videos on it, and I don't hear nobody talk about it. You got to have jurisdiction in a court. Okay, we talked about that. State courts have to have jurisdiction. They can have it. I'm not trying to get complicated. They can have it over the person. They can have it over uh, the property. If you have property there, you can get long arm jurisdiction from another location. You can also, and then they also have to have, they got to have subject matter jurisdiction. It has to be it can't be a federal law you're suing over in state court unless there's a state analog, meaning there's a mirrored or an analog statute for the state that mirrors the federal one, but you're still not doing it as federal law. You're doing it as state law in state court. You go to federal court for state or federal court stuff. Now, what do you need in a federal suit? What are we talking about, chat? Come on. I know you're thinking you got to have subject matter jurisdiction. You ever heard the expression, and this is a real deal, don't make it a federal case? Hey, don't make a federal case out of it, dude. That's a thing. It's an actual thing. And I'm not going to go pull up all the damn statutory subsections, whatever, but that's a thing. You got to have in a federal court, you got to have diversity. The parties cannot be from the same state. What we're about to go through and look at does change that. Basic is you cannot be from the same state, period. So you cannot have two Georgians suing each other over some silly ass contract or something in federal court. You just can't. You got to have a controversy over 75, maybe 70. I think it's 75,000. Has to, or it's gonna. You can't take it. They'll boot it. 75,000. Anything that's $25 or more gives you a right to a jury trial. That's constitutional. It's actually in the Bill of Rights. And you've got to have subject matter jurisdiction for the federal district court. Now, that jurisdiction, that subject matter could be, you might see a case, well, this is about state law. I mean, that's okay. They can do that. So long as diversity exists and they have the ability to have the subject matter jurisdiction over it. If it applies, they can do it. If the other things fall into place. So you've got to have subject matter jurisdiction. You've got to have the controversy over 70 or 75,000. You've got to have diversity of citizenship. You've got to have somebody from Georgia suing somebody from Alabama or somebody from Montana. Period. Without that, it's dead. You're going back to state court. That's it. Let's see. That. Let me go through that. Go back through there. Subject matter jurisdiction, 70, if it's $25 or more in controversy, you get a jury trial. So yeah, everybody asks for that. I don't think anybody's going to be suing for $25 is a lot of money in 1787. They've just never changed it. So that'll get you in a federal court. However, there is a way for two Georgians to sue each other. And in this case, it's just not, it's more related. What I'm about to say is more related for the Fox case, the sexual harassment, Skip Bayless Fox Sports case. In that case, you have basically everyone alleged is California citizen. Well, you can't go to federal, they're in state court in that. So you could not go into federal court, or excuse me, everybody's in state court with that, which is fine. Okay. So you couldn't go into federal court with the other lawsuit for Fox. So if somebody's ass grabbing in the office, right, and does a bunch of everybody, and he's the head of Fox, and Fox is not headquartered there, but works there and has an office, you'd sue him in state court. You wouldn't go to federal unless you sued them in Delaware. Now you've got diversity. Even though some of the people are in California that you're also suing, you can get it. There's some kicks to it. There's some tricks to it. That case, I'm not sure. I'm not sure why she didn't. Mrs. Faraji didn't take it to federal court because it's bad enough, and she meets the criteria she should have. Maybe California's got some better remedies. I don't know. Go watch that video though to see, and you'll see what I mean. In this case, with dumbass freaking Alec Baldwin, he gets granted the greatest gift of probably his life by not going to prison. The state made some screw ups. I don't know that they were malicious about it. He sure as hell ain't gonna be able to prove malice. So what is he suing for? And a host of other things. He is suing and a damn new. This is where it just doesn't make sense. I get the other case, the Faraji case, Fox. I get why she filed it in state court. You go back, watch it, you'll see what I mean. This one, I don't get it. This is New Mexico. This is a New Mexico district court for a United States civil right claim. They don't have subject matter jurisdiction. It's over. Right here. Done. They do backdoor it at the very end, and I'm hoping we have enough time because I'm already 26 damn minutes in for ranting and raving about the law school. So we'll probably have to do a third video. My other one was much shorter. There is a backdoor at the end of the complaint where they do use New Mexico law. In New Mexico, I guess I haven't gone through it. We're going to go through it together, but they do have a civil rights statute. But they're still not suing just under that alone. They're actually right here. Like it is lit right here. First claim for relief. Violation of rights under 42 USC 1983. That statute, you can look it up. I'm not going to pull it. It takes too much time. Goes to, I think it's 1871 or 1872. Ulysses S. Grant signed it, and after Congress passed it, pursuant to the 14th Amendment of the United States Constitution, to provide for the protection of civil rights for former or freed slaves. It's called the Ku Klux Klan Act. That's what it's called. You can go look it up. So normally, the other bad side of this is normally you have, I think I mentioned the first one, you have Chisholm v. Georgia. There's 17, I think it was 1797, 1787. It's one of the first cases that came around to Chief Justice Marshall's court, basically saying, "Hey, I'm in Georgia. I'm suing the state of Georgia," and he could. It was in federal court, and the state of Georgia said, "Hell no, you can't do this. We are a sovereign state. We cannot be held into court unless we consent." Well, they passed the 11th Amendment to stop that problem because he was able to do so. So they made sure to pass that amendment immediately thereafter to stop it. All right, so states usually have immunity, qualified immunity, and their agents, except in this case where they're acting under state law, under what's called color of law. They have to be doing something that violates your civil rights. Now included in those is the Second Amendment. Should have been always. Don't know why they chose not to. That's the Supreme Court for you, picking and choosing. So this one, he's suing for a violation. Let's see if I can get my thingy working. What the hell's wrong with this? Come on. There we go. Violation of civil rights under 42 USC 1983. This is going to be, is this his actual first claim? Hang on, chat. I want to make sure this is not the second one. Nah, it's the first one. All right. I thought it was the second, even though it says first. It looks, anyway. You'll see similarity. Conspiracy. All right. Malicious prosecution. That is a state claim tort. You can do it in federal court if you have diversity. We don't have diversity. Well, I mean, he is. I'll get it back. He is. This is where I keep coming back to. I don't understand his stupid ass lawyers doing this. If you have diversity, you can take it to federal court. We're fine. If this was a federal suit, we'd be fine. No problem. Once you allege diversity and meet the other, good to go. Not happening. We're in New Mexico District Court, Santa Fe. Why in the hell is he pleading 42 USC 1983? I don't know. It just doesn't make sense. This is shit you do in federal court. Always. Always. Unless you do it under the New Mexico Civil Rights Act, which we'll go over probably in the third video because it's getting too long. All right. Malicious prosecution is usually, almost always, common law tort. Sometimes it's statutory, but usually it's a common law tort. So he wants to sue for that and that they deprived him of his civil rights. Again, you can do a common law state tort. Remember, guys, when you bring up a case like this to federal court, you can pick, once you're in, you're in. You're in like Flynn. You can piggyback state tort claims on top. You're good. You don't have to, not every one of them's got to be there. You just got to have something get in the damn door. This doesn't get in the door or this gets in the door for federal court if you had your, because you've, look, Baldwin's from California. It may even be New York. I can't remember. It says it. He's in Santa Fe, New Mexico. He's suing them. That's diversity. Instead, he decides he's going to sue it in state court. I don't know. I don't know, chap. I don't know. This doesn't make any sense. So the defendants, while acting under color of law, which is a requirement in the statute, it's under federal law, that has to be the allegation. Has to be, and it has to be what they were doing. They can't be Joe Bob, the policeman that, I don't know, when he got off of work one night, he happened to have his uniform on, and just beat the hell out of some dude privately or whatever, and it wasn't under color of law. You could argue and say it was because he was in uniform, but let's say he wasn't in uniform. We'll just go with the easier one. Just because he's a cop doesn't mean that the state would ever be, or city would ever be liable for what he did as a private man. He'd be on his own. So you got to be operating in color of law. They conspire to procure, this gets me, a groundless indictment. And we'll talk about the malicious factor too, because malicious prosecutions, nobody takes them. It's too hard to prove. You have to prove malice. You have to prove that there wasn't a preponderance, essentially, even though that's something, well, not a preponderance. You have to prove that it wasn't, that the state did not have that it was more or less more probable than less probable that the defendant may have done the act or the crime. That's all they got to do in an indictment, guys. That's it. That's all they got to do. So you have to prove that that was maliciously brought and that you won. Having the way he won this by just having the case dismissed because they freaking screwed up in the in Brady material, doing discovery, that's probably not enough. He'd have to be acquitted. And even then it's hard. So you're not going to find a lawyer. I take that back. It's going to be hard to find a lawyer to really ever bring these claims for malicious prosecution or even the abusive process. All right, so as usual, we're 30 minutes in and I freaking hadn't even started. Here we go. Let's get it going on. Let's see. They maliciously tried to bring about Baldwin's trial and conviction, and somehow that thus violated his constitutional right by their improper use of the criminal process. Again, they only had to show a grand jury the evidence, not the exculpatory evidence, guys. Inculpatory evidence that they believed, and that it was more probable than less probable. That's your probable cause, okay? That he did it. And it's up to you, bucko, to prove it at trial that he didn't. But oops, I forgot. They have him on camera shooting her. So, anyway, the defendant's conduct included was not limited to following acts furtherance of a conspiracy. Let's see if I can't get this to. I doubt it's going to work. I keep having issues with the highlight function, and I don't know why. Let's do green. Yeah, that works. See, yep. Now it's acting up again. Damn it. Why is it doing this? Let's see. Yep, can't get it to work. Oh well, we'll just stick with this. Yep, I can't highlight. That's great. Just fantastic. All right. This is the furtherance of the conspiracy. Here we go. Defendants. All these people that we've listed all of them before. So in the if you missed it, go to the last video. I ain't going through all that again. A bunch of damn names. Other members of law enforcement, or they directed law enforcement to deprioritize the investigation of the source of live ammo. They don't. That's a defense. That's a defense issue. The most they have to show is it was there. They don't even have to show motive for murder. They just have to show that it happened. and someone caused it. That's it. So that's for their first wanton. Investigation of live ammo on the Rust set. And into the key suspects related to that inquiry. Well, you shot the damn gun, dummy. And instead, and to focus instead on obtaining witness that could be used to manufacture probable cause. Wow. Okay. With the explicit motive of disproving Baldwin, said during what he said during an interview. Yeah, he was a moron. I didn't pull the trigger. Yeah, well, it's a single action Colt replica. You have to. You pulled the hammer back for it to go forward. You pull the trigger. Ding, single action. Double action means you just pull the trigger. It cocks the hammer, gets to the point where the sear flips, and goes bam and fires the round. In the last video, I went in way more detail about the type of firearms used, and we just don't have time for that. So go look it up. Look up Colt SAA. That'll give you single action army. That's, I'm pretty sure, what the replica he was using. It operates the same. It's a black powder pistol. They shouldn't have been shooting live ammo. That's it. The end. They shouldn't have done it. They're all negligent. They're all culpable in this. He's the one that did it. He should have been the one guilty of manslaughter. They're all guilty of negligence of some sort. And unfortunately, God, what was the armorer? I think it was armorer. She got convicted. She in prison. This dude got to go home. And look, I don't disagree with the judge's ruling. They had to. They screwed up. Probably borderline ethical issues. And how they did it. I'm hoping we can get into that tonight, but I don't think so because I've rambled my mouth for 30 damn minutes longer than I was supposed to. So you got two bonuses. You got this and you got the law school. Me preaching, don't go. With the explicit motive of disproving what Baldwin said during a televised ABC interview that he did not pull the trigger. Guys, don't, if you ever get in trouble, do not talk. The cops, law enforcement, or the cops, the press, your mama, your daddy, your sister, your baby's mama. I don't care. Shut up. Damn it. Make it easy on the lawyer. There's nothing worse than going, man, did you say any damn thing? No, man, I ain't saying nothing. And you get into court and they say, well, the defendant stated that on this date, he went and purchased 8 ounces of methamphetamine, took that amphetamine. You're like, what the? I thought you said you didn't talk to anybody. Oh, I forgot. All the time. Happens all the time. The defendants, Hancock and Popple, requested, ordered, and approved destructive testing. This is what I went into in the last video. Damn it. And it's important. Destructive testing on a firearm is going to get used. If I tell you that I didn't pull the trigger and it just went off, they got to figure out how. They may take a rubber mallet and just bang the back of it. They're not, there's no bullets in it. They just need to see if the mechanism engages or disengages the safety. They may drop it. They may have to do it to the point of failure. Sometimes, if you're lucky, you can work with the state and go, look, man, we want to be there. We want our expert to be there with your expert. Watch you do it. Hey, no harm, no foul. Usually that's doable. No, that's no problem. They didn't do it. They just let them do it and it got destroyed. Oh, well, you should have gotten your crap together. They approved the destruction of testing of a firearm without documenting its internal components. That is a problem. They should have done that. Knowing that it would prevent Baldwin from examining the state firearm or the state of the firearm as it existed on the day of the incident. Again, they should have been involved in this instead of putting their head in the sand saying, I don't know nothing. That's a bad idea. All right, so the defendants charged Baldwin with a firearm enhancement. This is their screw up. That was legally barred on an ex post facto clause of the United States Constitution, which for there could be no probable cause. Okay. There was apparently after this happened, he was only going to be able to serve, I think, a max of 15 to 18 months. I know, shocking, right? A year and a half. They wanted 5 years. They changed the law. So what usually ex post facto means it's what the Brits did. You know, that, well, it's now illegal to buy knives. We'll just say that, or forks. Everybody started forking in, but it's also illegal to buy or to have possessed forks within the last 20 years. It wasn't illegal up until the time you changed the law. Everybody gave up their forks. Yes, but we have testimony that the law doesn't say that. It says we can do it for the past 20 years, and we have testimony from people, affidavits saying that you had forks. That's ex post facto. You still can't charge him with an enhancement saying, oh, well, we've just enlarged it. Of course, they've tried to do that with Trump and everything else with um, uh, opening the statute of limitations. Oh, we're going to do it. 20, 30 years ago, if you had a case and you were assaulted, raped, whatever, we're going to allow you to bring the case again, even though you knew it happened and you should have brought it within, let's say, 2 years. Okay. That's a problem. And they don't have the ability to do that in this criminal case. So that was a screw up. It's not something that should have killed the case. I don't think it was to that level. It should have just killed their ability to sentence him for that. So, but again, that's what they're relying on. All right, big deal. Ex post facto clause in the United States, which there could be no probable cause gained because they weren't supposed to be able to do it. The defendant's simultaneous role, and this is bizarre, the state legislature and defendant. This is all political bullshit. This is what happens with this type of job. You got a chick getting made into a special prosecutor while she's running for the legislature. Not a good idea. I don't think it's a bar. I still don't think it's a bar. I think it's a stupid idea. I think it looks bad. It's not a bar. Period. But I don't know New Mexico law. That's what I forgot to do. I'm also not your attorney. I'm also not giving legal advice. I'm not doing anything but opining on bullcrap things that happen in the law. That's it. I am licensed only in the state of Alabama. And that's it. I'm not your lawyer. Don't take this as advice. This ain't legal advice. If you got a problem, go find a lawyer. I hate to tell you that. You do have the right to do it yourself, but I don't recommend it. A lawyer represents himself as a fool for a client. I know, I've done it. Don't do it. Hire somebody. Start going and selling your blood because you're going to need it, and your firstborn child, probably to like Beelzebub, because that's how expensive it's gotten. Because of the defendant's simultaneous role in the state legislature, here we go. Defendant, I don't know, whatever the name is, statutory inability to prosecute Baldwin alongside a special prosecutor under this New Mexico state statute, which I haven't looked at. I'm not going to. We're not going to. We're just going to assume they're right. The defendants lacked constitutional statutory authority to charge Baldwin with any offense. Okay, that's still not, look, that's still not a deprivation of his civil rights. It's not malicious prosecution. That's crap that you handle on the front end before the indictment, and definitely after the indictment, and you bring a motion to dismiss the indictment. And of course, all they're going to do is say, Judge, we're so sorry. You know, come to think of it, we just moved to dismiss without prejudice. Oh, thank you. Thank you, Judge. Thank you. I see your ass in court in about 2.5 weeks. That's what they're going to say to you as you walk out. Because they're going to come right back and charge you all over again. And this time they're going to do it right. The without prejudice is the kicker. With prejudice means it can't be brought again. This case was dismissed with prejudice by the judge because they do something soon. That's a big deal. Again, whether or not it rises to a civil right violation, I don't know. Maybe New Mexico civil right violation, maybe a tort case in New Mexico. But again, usually most states don't let you sue people involved in law enforcement, because if they did, that's why they have sovereign immunity and judges, because if they didn't have it, everybody would be suing the damn cops, law enforcement, and everybody. Nothing would happen. D, defendant Reeves' simultaneous role in the legislature, and defendant Carmack's inability to prosecute Baldwin alongside a special prosecutor. There's the statute. Defendant's last contact, blah, blah. All right, we've read that. Defendant Carmack Altwest appointed defendant Morrissey as special prosecutor with the understanding that she would advance Baldwin's malicious prosecution. I like how they stuck that in there. Not prosecution, malicious. They write this like it's a freaking. It's almost like he hired a lawyer to write it, and then the Hollywood writer went behind him and rewrote it. That's what it reads. And continue to contribute FJDA resources. I'm not sure what it is. Don't care. We're moving on to Baldwin's prosecution in violation of that statute. At the request of defendant Morrissey and the furtherance of Morrissey's malicious objections, defendant Hancock presented false, distorted, misleading, and perjurious testimony to the grand jury to procure a criminal indictment in the absence of probable cause. Well, guess what? There was probable cause because the grand jury found it. The end. Done. It was more probable than less probable that his dumbass was on video shooting a gun that killed a woman and shot a man. Not hard. It is not hard. Ladies and gentlemen, that is as easy as it gets. It's literally walk in, introduce the law enforcement officer. They talk about the case. You go, ladies and gentlemen, grand jury, here is Exhibit A. Pow! Thank you for coming. We'd like you to return an indictment on this case for murder or manslaughter in this case. That's how this isn't complicated. Grand jury, even for murder, they don't take long. Oh, freaking stupid thing. I think I just hit. Now I know why the damn thing cut off before this. Okay. So this is easy. Probable cause not hard. This is, and yes, anybody can get indicted for anything. I can indict you tonight for a homicide, most likely, give me enough facts. It's not hard. It's your job to go and prove that you didn't do it and win the case. So for them to sit there and say, oh, well, it was malicious. Was it? I don't think so. I don't like the guy, but I don't think it was malicious. He does have a good argument why he got the case dismissed. I would have dismissed his case too. And it sucks because other people went to prison when he should have. All right. The defendant Morrissey knowingly failed to disclose. Here we go. Big time problem. Big time problem here. Knowingly failed to disclose exculpatory info that she had received from state witness experts or state's expert witnesses. Now, this doesn't matter as much. You don't have to provide all the evidence you have to a grand jury. You just need enough to get the indictment for the charge. Like, for instance, I don't need to provide all the evidence I have for the charge of manslaughter if I'm not going after manslaughter. It's, if I try, I can't go later and go, oh, well, you can do a superseded indictment. Let's say you got evidence later on. You could go back and get a murder one charge, a superseded indictment. Or some states may require you to dismiss the case and bring it again, and then indict it correctly. This isn't a thing. Maybe some states are. Alabama, not a thing. No, not a thing. You just bring the evidence you need to prove the charge. You prove it. They're not going after him for murder one. They don't need to. They just need to provide enough to get a manslaughter conviction. That's it. Or negligent homicide, whatever it was they charged him under. I don't even know what he was charged at this point. I just know he needed to go to jail, but it didn't happen. Undermine the case against Baldwin, or in the alternative, administered policies and practices with respect to the disclosure of evidence that she knew were inadequate to fulfill her constitutional duties to Baldwin. Well, she doesn't really have that many constitutional duties to him. She does to the state and her job. She does have them as far as basic constitutional protections, like what she's about to get nailed on for not providing evidence, exculpatory evidence. They're not required to provide the inculpatory, but exculpatory, that's a problem. It's Brady material. You got to do it. You got to do it. You can't mess that crap up at all. All right, so defendants Morrissey, Hancock, Popple, and Brandel, and on the basis of information and belief, defendant, whatever, it intentionally caused and or agreed. This is where they're connecting the conspiracy to cause exculpatory evidence not to. This is a big problem. Big issue. Inventory to the Rust case file, but instead to be inventoried by creating a new case number. Now, this is starting to become extremely unethical and extremely dirty. This is why the case got dismissed. By creating a new case number and inventorying the evidence to the new case number, failed to disclose the evidence to Baldwin or to make it available for his inspection All of these are required under Brady. Problem. This got his case booted. That's it. It's still not necessarily a violation of civil rights because you can't prove malice. I mean, 9 times out of 10, a civil rights case is going to be, you know, the, look, the cops beat the hell out of me for no reason. They executed a warrantless search and seizure, and I don't know, took everything I owned, sold it all, seized it, everything. It's all gone. I have nothing, and I'm now broke. And it's because of them I'm broke, and because of their illegal search. Well, the state's not going to let you do a damn thing about it, but the feds will. They kill your they kill your brother because he's black. I mean, seriously, and they even say they did it. That would violate his civil rights. It would also violate his state rights, but that would get you under the traditional idea of the Ku Klux Klan Act. That would get you there, and it damn well would if you did something to suppress their civil rights. For instance, doing something about, like, I don't know, gee, what's the thing that the Klan always did? Oh, yes, right, burn crosses in your yard, and to intimidate you from voting. You could get nailed from not only the feds nailing them for civil rights violations, but then if that's a state employee doing it, if it was a state employee doing it, you could sue them under 1983 and the state, both in their capacity and the state, for what they did. That's the point. It was to stop that. That's all. That's what it was meant for. And it's a big, and it's needed. We need to really peel, really, we need to peel back a lot of this immunity crap. There's way too damn much immunity, especially with judges. And they have hard decisions to make at times, but you know what? They get paid to make those decisions just like a doctor does. If the doctor screws up, they don't just get to go, I'm immune. No, they have to open their pocketbook. Each of the overt acts was in furtherance. See, they have to prove that too. There was an overt act in furtherance of the conspiracy. See, I didn't even get to that part. There we go. Conspiracy to deprive Baldwin of civil rights. And throughout the acts described above, they acted in concert pursuant to the agreement, meeting of the minds, blah, blah, blah. You got to have all that in there. This is important to prove conspiracy. Conspiracy is two or more buttholes conspiring to commit a crime, and it requires an overt act and furtherance thereof. Carrying out the conspiracy, defendants were driven by ill motives. They were just pissed off. Well, okay. That's okay. Good luck with that one. And to accomplish illegitimate ends, including to harass or humble Baldwin, to promote their political agendas. Now, and here's what's funny. Everybody knows Baldwin hates Trump. Hates the guy. He probably wishes his death nightly. I mean, I'm just going on. I'm not even going on based on his really not so good impersonation. Just on what he says. And it's kind of rich. I could see if it was a bunch of Republicans going after him, but I did look this up. These are all Democrats. They're all Democrats going after him. So his own party's eating him alive. So it's kind of ironic. It is. It's ironic. To promote their political agendas or to further their own personal agenda or professional ambitions. Now, that's common. Hell, every prosecutor does that. It's absurd. And some of these are cops. Man, cops didn't care. They freaking just try to do their best job that they could. They didn't care. They just did what they had to do. I assure you, man, the cops did not care. In fact, if anything, because of who it was, I would think when I did crime scene, dude, anybody that had any kind of clout, you made double sure you didn't F it up. You made sure you wore gloves, made sure you bag and tagged everything, and signed it, made sure you had a chain of custody. You should do it anyway, but you made damn sure because you knew it was going to come back. And they should have known this was going to happen with them. The defendant's actions violate constitutional rights guaranteed by Baldwin by the 14th Amendment of the United States Constitution. I may actually pull that real quick. Let me hang on one second. Let's look at that real quick. I think that's important. Secure it. Let's look at it. Oh, I meant to tell you, the case earlier I was talking about, um, that that spawned the 11th Amendment. It's Chisholm v. Georgia, 2 U.S. 419. It is from 17. Yeah, what? 1793. Sorry, I think it was 1792. It was brought. And citations. Yeah, I got the citation right. All right. Anyway, so it says the Supreme Court ruled that the states were subject to the authority of the federal government. The decision initiated a series of events culminating in the 11th Amendment of the Constitution, limiting the judicial power of the United States Supreme Court. You can go read it, pull it up. It'll say the state can't be sued, okay, unless they consent. And until after the war between the states when Grant had that passed. All right. So we are looking at 14th Amendment. That's what it was. Let me look it up real quick. Sorry. I'm trying to get us out of here, guys. I'm sorry. I'm hurrying. No, I don't want the Equal Protection Clause. Actually, this one may cover it. I think everything's, yeah. Am I still on? Yeah, I'm still on. Let me just try this. I'll make sure I get it all. Okay. So really, the interesting thing about 14 minutes, it's been used to just completely go nuts with all kinds of rights. No, you got a right to an abortion under it. Nah, no, you really don't. No, you don't. You can put the Bill of Rights underneath it if you want, and attach it to the state governments, which was the point. But the real point of it, guess what it was really about, chat? Guess what? He had a whole lot of people after a very bloody war. 600,000 people were murdered in battles. 660 some odd thousand. Based on the population of the war between the states at the time of the U.S. at that time, by 1865. Today, that would be 12 million people murdered. 12 million. Forget Ukraine. Shit, forget World War II. We lost almost 500,000 souls in that war. Just us. Don't go, well, they killed 60 million people. Talk about us. So, you had a lot of people here, though, that weren't citizens. And that after slavery was illegalized, what do we do with them? They didn't know. Many states were trying to restrict them and treat them as second class or no class. So it granted citizenship to these people. They made them citizens. Then they had to then make sure their rights were protected. So I'm going to read it to you. No, I don't want that. I want the dadgummit. I want the full amendment. Why is this so difficult? Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of these United States and I can't say and enough, and of the state wherein they reside. So you're not just a citizen of the United States. You're a citizen of both. So next time somebody says, well, where are you a citizen? If you live in Mississippi, you're a citizen of Mississippi and the United States. You can't be one without the next. Period. You don't like it? Take it up with the damn amendment. I don't know what to tell you. No state shall make or force any law which shall abridge the privileges or immunities of the citizens of the United States. Remember what I said earlier too? There may have been the other one that got muted. There's a whole lot of other rights that we don't talk about because you don't have to. I have a right to get married. I have a right to go from New York to Illinois, get married in one state and go back to the next, and they can't say, oh, we don't recognize that. I'm sorry. If you, yes, you do. It's a valid marriage certificate. They can't tell you when you come into South Carolina like they'd love to from Georgia and say, oh, you got a Georgia license there, boy. This ain't no good, hell. You going to jail. No. Privileges and immunities clause. So the whole gay marriage thing was stupid on its face. I don't know why. It didn't matter. I don't give a shit if Alabama wants to ban it. I don't care. I had friends that went. They went to New York, got married, came back and said, "Poof, deuces." What were they going to do? The insurance company couldn't say no. They couldn't say, well, Alabama law says public policy. That don't matter. Privileges and immunities. So that's my little bitch session for that. It just always irritated me. I don't want to take away the rights of a state. I just, period, end of story, don't want to do it. If you can give it to them, let them have it. But there's always a way. If you have to enforce a right, there's a way for it to be done constitutionally. Okay. Um, let's see, which abridge the privileged immunities of any citizens of these United States, nor shall any state deprive any person of life, liberty, or property without due process. Big deal. This is what gets you into court here, guys. Chat, this will get you into court. Um, let me, hang on. Let me do this. Hey. Um, here, yeah. Good. Yep. There we go. Perfect. Awesome. All right. Yeah. Versus any state without due process of law. There's your 1983 action right there. This is what it comes from, right there. Or denied to any person within its jurisdiction. This is what sucks. I'm still not. I'm not sure how I feel about it, but I don't believe. Actually, I'm really just not sure of it. Because 150 years ago, you could come from Mexico, buy a gun, carry a gun, provided the state allowed it. And it was no problem. There's no problem. I mean, you weren't even a citizen because the state made you the citizen. Then you became a citizen of the United States. But you weren't necessarily denied, but you could be denied that right. It just wasn't done. And my point is that it says, nor denied to any person within its jurisdiction. And I don't know why they chose that instead of saying freed, formerly unfreed persons or something, because that's what they were going for. I mean, let's be realistic. This is literally after the war ended. They just passed the 13th. Then they had Southern states reinstituted because, magically they did not secede, even though they did. And the same guys went back to their same jobs. Problem. So that's when Reconstruction began, and they threw out the state governments, which in and of itself should have been illegal. But be that as it may. The purpose of this amendment was to protect former slaves that may or may not have been born in these United States. That's it. Because you have to also remember in the Constitution, and I'm not going to go through and look at it. You can go look at it, read it. It's in, I think it's in Article 1, if I'm not mistaken. It says after the year of, I think, 1803 or 1806, it's somewhere in the early 1800s, the importation of slaves is prohibited. Now, they had people that did slave running, just like they do today, man. God, it's every time I hear sex trafficking, I just want to slap the shit out of people that say it. It's slave trade. It's a slave trade. If you don't have the right to say, I don't want to, and you're not getting paid, it's slavery. Stop. It's slavery. It violates the 13th Amendment. There's a lot of, I'm sick of people just not wanting to be ballsy enough to say, you know what? No, no, no. This is slavery. This is slavery. What we're allowing is slave trade. So any person within the jurisdiction of the equal protection of the laws. I'm not so sure they meant for like a Ukrainian who came here illegally would have the same constitutional rights as you or I. And I say that, go back to the Mexican guy who came and maybe he didn't live in an area that had where he could buy a gun. He goes across the border to Texas, goes to a country store, and got him a gun. Yeah, no big deal. Nobody cared. Texas didn't care, but was he protected by the United States right or law? I don't know. He was definitely protected by Texas law because if he killed somebody, his ass was going to get tried, convicted, and probably hanged. That's how they did it. By the way, the last public hanging in the United States was in the 20s in a place called, come on, come on, Owensboro, Kentucky. I think it was 1927. It was a public hanging. You can look it up and you'll see the photos. A lot of people have shut up. Kentucky's a bunch of complete wuss asses now when it comes to crime and punishment. They don't like doing it to anybody. They don't even want to execute nobody. Jeffrey Dahmer and Ted Bundy could get a bond in Kentucky. Section 2. Representatives shall be apportioned from among the several states. We don't need to go over that. This goes over. Everybody's talked about that. Let's see. Yeah, it talks about president. Yeah, everybody's read about this stupid ass, silly Trump stuff and insurrection and all that crap. It's not what it says in here. In fact, I tell you what, the hell with it. Let's just look at it. I got nothing else to do. Let's look at it. Let's see. Where is it? Sorry, I'm trying to read it here without reading it out. Here we go. Members of the legislature thereof is denied to any of the male inhabitants of such state being 21 years of age and citizens of these United States or in any way abridged except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion of the number of blah, 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 blah. That's not it either. What the hell is it? Oh, yeah, here it is. No person shall be senator, representative in Congress, or elector of president and vice president. I didn't say the office, I said elector. Or hold any office, civil or military. Remember, the president is a military, he's a commander in chief, but he's a civil office. Under these United States, or in any state, who having previously taken an oath as a member of Congress or an officer of these United States, they're talking about offices of these United States. Usually when they say officer back then, they meant military. Even if you want to take it as far as government elected, it still doesn't apply. Or as a member of any state legislature, that one would, or as any executive or judicial officer, here we go, executive or judicial officer of any state, we're not fed, state, to support the Constitution of these United States shall have engaged in insurrection or rebellion against the same, either, it's saying same, meaning U.S. or the state, or given aid or comfort to the enemies thereof, but Congress may by a vote of 2/3 of each house remove such disability. What is not listed in that, chat? Can anybody tell me? Oh, it says, it does not say no person shall be a senator or representative in Congress or the president or vice president of the United States or an elector for the president or vice president. That's the difference. Thank you. Shut up, everybody else. I am sick of hearing that crap. Read the damn amendment. Nobody reads it. So, anyway, I've gone over there. Now you know where the 1983 law comes, or the section 1983 comes from. Okay. I hope that gives you some kind of an idea. Let me, now let me present this. Hang on. The hell did I just do? No, I screwed up. Damn, I screwed up, guys. No, I did. Shit. Come on, work. Let's see if we can get it to work. Or I'm going to have to do another damn video. I think I got it. We're back. Yes. Thank you, God. Hallelujah. I didn't mess up too bad. Okay, so now you know how 1983 applies. We've applied that. We've shown where it comes from, how it applies, how it protects you via the 14th Amendment. That's important because otherwise you don't have that. The 42 USC 1983, if I had not closed it out, it says at the very bottom of the 14th Amendment, Congress shall impose or enforce this enforce this amendment or something to that degree by appropriate legislation. That's USC 1983. All right. The defendant's actions violated constitutional rights guaranteed by law. We did that. The immunity typically afforded. Oh, Lord, we got to talk about immunity. Dear God. My last video was so much damn quicker. Immunity typically afforded by a person, afforded to prosecutors acting in their quasi official judicial role, does not apply to the actions taken by these people because they were performed in an administrative or investigative. That makes no sense. It's always the way it applies. Beyond their prosecutorial function. No, it's exactly what they were doing. Before any determination of probable cause was made, that's how you got your damn ass into the case. That's how you get indicted. Outside any of any statutory authority or judicial norm pursuant to an invalid appointment. That's a good way to argue to say, hey, these people can't prosecute me and the indictment should be quashed. They'll just rebring it. This does not stop you from that's funny. This does not stop you from being prosecuted. They're just going to rebring it. The immunity typically afforded to prosecutors acting as their quasi-judicial role does not apply to the above actions undertaken by defendants, including because they were performed in administrative or investigative capacity, blah, blah, blah. We already read that. They just keep restating the same shit over and over again. They were not undertaken in good faith. Good luck proving that, and were clearly in violation of clearly established laws. Okay, when you do dumb stuff like this and you say dumb stuff like this, make sure right about in here you actually say what the hell the law is. Don't just make it a guess. No, don't do that. That's really bad lawyering. Defendant's actions were unnecessary, unreasonable, unlawful, and unjustified. Says you. This is really written bad. Now here we go. Why it got dismissed and why I think it was okay to do it. On July 31, 2024, the trial court dismissed with prejudice. That means it can't be brought back. He's done. He is so done. He is lucky. Lucky. God, he's lucky. You never see those words. Dismissed with prejudice. You get your butt in trouble or something and you hear it from a court, the judge is going to say dismissed without prejudice, meaning they can rebring it. Do they? No. But they could have this one if the judge had said it. But the violations were so egregious, and they were Brady violations. And they were pretty bad. I would have done what she did. I would have said, "Look, man, the only thing I can do that is a sanction that is good enough is to say your case is over." She could have just said, "You're not using any evidence that you did this with." It still would have killed the case. But there's no. The judge was right. She was right. All charges against Baldwin on the grounds that the defendants, I love this, and there's no citation as to make sure this really is what was said, but I think it was kind of close, that the defendant's egregious discovery violations, suppressed evidence, and false testimony deprived him of his constitutional right to fair trial. Yeah, but here's the here's the fix. The case is dismissed, and he can't be recharged. It's arguable, but not very well. But again, maybe because they filed this in God, they're so stupid. They filed it in New Mexico courts. Maybe the New Mexico courts have more leeway than in federal, but in federal, which your 1983 class or your those type of class suits are brought, this is not going to be enough. And here's the biggest one for their. Remember when we talked about? I said that you have to, in a malicious prosecution, you have to be called the winner. You got to be victorious. Yeah, it's a good one. He might be. They might say, yeah, this is enough. Usually, it's you got to get a. You've got to show that they had malice. You got to show they did some bad shit. And then you've got to show that you were acquitted. Or that the court said, hey, I'm dismissing these charges because you ain't got probable cause, and he didn't do it. I don't think he did it. You don't even come close to proving it. You ain't got that either here. Because the standard is low. It's a low standard. You don't want people being able to sue constantly for malicious prosecution. They just don't. So the grounds for the trial court's dismissal of charges against Baldwin are indicative of Baldwin's innocence. No, 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 they're not. No, they're not. It's indicative that they screwed the pooch and hid stuff. I mean, yeah, I mean, this happens sometimes with Brady material that's not even purposeful. That just somehow they didn't give it to him, and the guy got convicted, and they overturned the conviction, and they're like, "Hey, man, look." Um, or before it even gets to that point, they find out, and they're like, "Look, you can't use that evidence. You should have gave it. It's potentially exculpatory." But the trial goes on. They just can't use it. It doesn't mean he was innocent. He's on video pulling the trigger. It's not hard. I mean, this was a slam dunk case. They just effed it up. As a direct and proximate result, I think I may just go ahead and end it on this. I think we've got time instead of doing another video. It's just this, we can do it. I think I can do it. If I hadn't bitched and moaned about law school for 25 minutes, we'd have been under the hour. As a direct and proximate result, that's the language you have to use to prove suits, tort. Direct and proximate result of the defendant's unreasonable and unlawful. I love how unreasonable and unlawful, not just unlawful or just unreasonable. Baldwin has suffered and continues to suffer substantial past and future damages. Finally getting into some kind of what did it do to him? What did you have happen? What is your claim? Give me some damage. You got to have a damage. Both compensatory and general, including but not limited to legal expenses. I knew that was coming. Because he ain't going to pay. Loss of income. I doubt it. Severe emotional distress. Mental anguish. Embarrassment. Meh. And an amount to be determined at trial. Where's the punitive? Surprised they didn't throw that in there. Oh, there's another one under here. This is for the Brady violation. Okay. This is oh yeah, they did ask for it. Because they were motivated by an evil motive. That's really written poorly. It should just be actions were motivated by evil intent. And they say evil motive or intent, whatever, and involved a reckless or callous indifference to his rights. An award of punitive damages is appropriate to full extent permitted by laws. Probably not, but it might be. I don't think they're going to be able to prove it. It's just not going to happen. Second claim, still under 1983, this time for the Brady violation. And these are going to be the popos. Okay. They're going to say the popos acting under color of law. That's horrible. Let me delete that. That's going to drive me nuts. There we go. Violated his rights by intentionally causing or agreeing to cause exculpatory evidence not to be inventoried, but instead to be inventoried by creating a new case number and inventorying the evidence to that number and failed to disclose it to Baldwin. It was probably stuff that wouldn't have even made a damn hill of beans to the case. That's how dumb it is. I feel so bad for the woman that died and the guy that got shot and their families. It just sucks, man. This sucks. This guy, he should have gone to jail. He should be in prison. Maybe not the rest of his life, but he should definitely get what you or I would get, which is probably about 10 to 15. I'm just being honest. They failed to make it available for his inspection, despite knowing that the evidence was related to the case. Duh. Of course they knew. Stupid. Defendant's actions violated constitutional rights. Defendant's actions were not undertaken in good faith in violation of clearly established law. They're going to levy the same proximate cause here. Now, malicious abusive process. This is going to be for. They're telling you who it is in the county. It's going to be a state claim, which they're in state court, so that's a good thing. That would be a good thing. But in federal court, you could still allege it. That's okay. That's okay. We have issues called conflicts of law, which deal with all that stuff for federal court. Still would have been okay. He's just doing, this is what we all do. You don't just restate all 60 pages. You just reincorporate them. We'll go down here. With the explicit motive of disproving what Baldwin said is same shit, different day. They're realleging everything all over again, but this time under the Brady issue. Again, about the grand jury testimony. That's useless. This is the one that gets them under the Brady issue. This is why the case was dismissed. Hell, what the crap? Why is it doing that? I don't like that at all. See, this will work. Yeah, there we go. I don't know what happened. All right. At all times, defendants were acting in the capacity of agents, servants, employees of commissioners, and that is, well, we may need to do a third one. Damn it, it's an hour and a half. Damn it, I was wanting to get through. There is a New Mexico. They do cite it in this suit, New Mexico civil rights statute, and this is a requirement. That's to go against the body. Okay. And here's where they're citing it. So maybe I don't have to. I don't have to go through the whole statute. The immunity granted by that statute does not apply to liability for personal injury resulting from malicious abuse of process or the deprivation of any rights, privileges, or immunities secured by the Constitution and laws of the United States or New Mexico when acting in the scope of their duties. This is all that other crap. I don't even know how many damn pages. Right here, they could have done it with this. No USC 1983. Don't need to cite it. You're in state court. Let's just focus on state court law. Law of the state. That's all we need. You morons. That's all they needed. Oh gosh. That's all they needed. And then they're gonna spoliation. Let me give you, because this one we don't really need to go to. It's just this just has to, it deals with the uh, we talked about it earlier, the gun getting destroyed. That's all it deals with. So just know that the spoliation deals with the gun being destroyed. That's it. But I kind of do want to maybe read it to you. Let me see. Let's see what ChatGPT does. Yes, it's my buddy. There we go. Spoliation refers to intentional, reckless, or negligent destruction, altercation, or failure to preserve evidence is relevant to a legal proceeding. Now, intentional, reckless, or negligent. It can be any of them. Spoliation can occur deliberately. Again, guys, they had the chance to go into court go into the lab with the state techs. They could have done that. Trust me, they could have done it and had their expert test it and watch the testing be done. They could have done that. When you test a firearm to that degree, you're going to test it to destruction. You're going to test sometimes DNA evidence from a homicide that's 20 years old, and they say, look, man, we got one shot at this. Uno. That's it. One shot. We test it, guys. It's going to be destroyed. We're not going to have no more left. That's it. And a lot of the times, there's cases that are still sitting 20 and 30 years ago. DNA still sitting in a freezer because they don't want to risk it. They want to make sure they have technology to get it. What's the point? Well, chances are the guy who did it's dead now anyway, but at least you'll know who did it, hopefully. But that's the point of it. The evidence in question must be material to the issues in a lawsuit or investigation. So the judge didn't have a problem with the evidence getting destroyed by testing it. They had to test it to verify his defense. And they had a duty as defense to be there when it was tested. So that's what that one is. So now you know what spoliation is. Maybe you may get it or not. I don't think you would because, again, it's only about that evidence. It's only about the gun, and they had to do the destructive testing. See, now they should have documented the internal components, their status, their state, etc., pictures, etc. But they're not going to disassemble it, or usually they won't disassemble it because they'll say, "Well, you reassembled it to fail." They're just going to take it as it is and start dropping it, banging it. They're going to try to make it fail because they have to give a benefit of the doubt to the defendant that it might be true, that it did fail. but they didn't do that. So, destructive testing and defendant's failure to document the internal components of the firearm did, in fact, prevent. Then this is true, as it existed on the day of the incident, but they could have gotten involved. The state would not have precluded them. I've never heard of that happening. They were acting in capacity of agents, servants, employees of commissioners in the county of Santa Fe. This statute is a New Mexico statute, immunity it's for immunity, saying that this statute does not apply for immunity to personal injuries from intentional spoliation of evidence or deprivation of any rights, privileges, or immunities of the United States or the Mexico Constitution by law enforcement. So he might actually have a shot at spoliation argument. But I don't know what's the point? I mean, you got your case dismissed, dummy. What are you going to get? What are you going to show them? I'm going to show you. Mm-hmm. I mean, here it is 10 o'clock. Damn, I got to go to bed. So I hope this has helped you. Well, I hope all my rambling has helped. I hope that you don't go to law school. Learn about it. You need to learn about the law. You need to learn how to defend yourself. Don't do it unless you have to. Please keep watching me though, because don't do it, especially in the guise of domestic relations law. You will get railed with a freaking giant fist right through your backside. I promise you, they will nail you because every damn state is a freaking corruption, especially Alabama's domestic courts are a damn scam. And I'm doing a whole series on it. Judges, lawyers, they're all in it. I call it Alan Dershowitz said, at least in the 60s in New York, he called it the favor bag. And it wasn't that you paid money to anybody. Nothing exchanged. It's just who you supported and were you in political favor. That's how it works. You go to one law firm on the one hand in Birmingham, and you get firm A. Well, they're in the favor bag. You go to firm D, who's just as good. Just as good. They're good. You have a good case. You're going to win. You're going to lose because you didn't get firm A or B. And maybe that's the only two the judge cares about. And they get all the cases. They get all the good results. So anyway, please watch that. I want you to please keep an eye out for it because it is something that means a lot to me. I have been screwed. I'm a lawyer of over 12 years. I have been screwed by damn courts and domestic relations. I've freaking seen it. I have watched my clients get railed. They might as well just get, I don't know, lined up and just a train run on them. It's horrible. These guys have nothing, and women too. They have nothing when they're done. Nothing because of lawyers and corrupt judges. Horrible. I had, in my case in particular, my late son, and please don't go, oh, I'm so sorry. No, he's a piece of shit. All right. He's a child brutalizer. And I put him in prison. And then, anyway, he victimized a baby. It was 4.5 to 5.5 years of age. I still pay child support. Court refuses. And the standard is just that there must be a I'm trying to think of I'm tired. I'm sorry. I'm trying to think of the actual wording of the Alabama rules. It must be a major change and a substantive change in the child's custody status or something like that. I'm sorry, but when you go to jail, what the is that? Why are you getting child support or allowing anybody to get child support for a child when they're in state custody from the age of 14 to 18? Ain't coming back. Sentence done, gone, or dead. Either one. They don't care. I got a freaking bench warrant on me. I'm a lawyer. I had to go to the Alabama bar over it to freaking do something. Nobody would do it. You know what? They're judge. Oh, we can't disbar them. You can't disbar them. They're a goddamn lawyer. They can't be a judge without a bar license. They don't care. Well, we can't do that. That's JIC. In Alabama, it's called Judicial Inquiry Commission. I'm sure other states have them too. Because the legislature are a bunch of pansy little wussies who won't do their job to impeach and remove. And I'm going to go over the judges. You're going to be shocked at how bad these people can be. Brutal. Brutal. Very brutal. And they don't get in trouble. Yeah, they might get a 30-day unpaid suspension. It don't matter. They make a 6-figure salary. They got money. And then they're put back on the bench to go and destroy lives. You just can't imagine what these people do. I had to pay 10 grand for a judgment for this son of a bitch's therapy for what he did. And I'm the victim. My child's the victim. All it came down to is mommy wanted revenge. And that's what the courts do. So that's why I'm doing this channel. It's not just me, it's other people. I have a long train of people I'm going to interview. I don't care who it pisses off. They can go F themselves. I'll tell the judge to their face, I don't care. Because you know what? No one else will. No one else is going to do it for that person. What about that little kid? What about that little baby? Who's gonna defend them? No, the lawyers that are involved don't give two shits. All they care about is making their money. And please don't get me started on guardian ad litem. I was that too, man. $125 an hour. This criminal appointment from the state of Alabama pays $70. Sounds like a lot of money. It ain't. Look up how billable hours work. In fact, take it better way. Go to your mechanic. Go to a Ford mechanic and say, I tell you what, man, you do billable hours. If I say you make $70 an hour, is that a lot of money? He's going to laugh you out of the damn shop. It's the same principle. It doesn't change. I may do, I don't know, an email or it's 0.10 of an hour, 0.10 of $70. That's it. GAO's 125 an hour. And it's always one dude in seemingly every jurisdiction. And buddy, the judges love them. They talk to them ex parte when they shouldn't. They do all kinds of shit. So anyway, I've been going on an hour and a half. I want it, please, just when I post a video up, especially an interview on somebody, please watch it. I'm I'm sure I'm going to get some pushback at some point from the powers that be. I don't care because I'm doing this for people that can't. And to be honest with you, it's more men than women. I'm being honest. It is. It's not always. It's not always. I have one friend she's become a friend over the last year and a half I've known her. And if I can get her to talk, her story will literally shock you if my story didn't. The amount of money that the court has stolen and confiscated off of her is eye-watering. So I'll leave you with this. Please, if you have crap you're going through and you feel like no one cares and it's legal related, there's those of you, I know the majority just like this for whatever reason. Look, for us that are in law, this shit gets boring. 90%. I could have done all of what we just did tonight in about, I don't know, 18 minutes, 20. But it's like any other job, it's like saying, wow, it'd be great to be a doctor. Tell me what it's like. And then the doctor's like, uh, you know, it's boring for him because we're used to it. So I'm very happy that people have. Thank you for subscribing and wanting to learn. I love teaching it. I love explaining it to people because most of the time people get a lawyer. Lawyers don't tell them a damn thing. They tell at them. They don't tell them what they need to know to make a good decision. Usually, they just say you should make this decision. But if you make that decision, well, then this could happen. How about explain the law as to why? There's never a why. I always gave my clients the why or the why not, or the you're so screwed. It's, you could, you could go into a whorehouse with 20 cents and you couldn't get more screwed, or excuse me, with $100 bill. You could go into a whorehouse with $100 bill and you wouldn't get more screwed than you're about to get because your case sucks. Um, this is this is honest. It was a it was a damn guy guy owed a lot of child support. I think he owed I think it was like $76,000. It was a lot, and he somehow won the lottery, won 100 grand, and spent it. And the judge, she was going to throw him in jail on a contempt, and she says, "You better have a damn good explanation. What the hell did you spend 100,000 on, and without missing a damn beat?" Hookers and blow. And he got about that quiet. And after I picked my tongue up off the floor and was wanting to turn around and just backhand the crap out of him, she just went, "Hell, I can't. He can't be lying. What am I going to say to that? At least he's being truthful." But that guy, that's the kind of crap they'll do to you in court. They will screw themselves right into a damn jail sentence. He didn't get one, believe it or not. There's no, what's she going to do? He didn't have no money. Put him in jail. Okay. He'll sit for 6 months. You got to let him go at some point. So, anyway, please like and subscribe. Leave a comment. I'm trying not to get too personal or emotional, because what I went through is and others that I know, it's hard. It's rough. I've seen a lot of bad stuff, and the only one that seemingly has come out okay on the other side of it, believe it or not, is my little girl. She is I don't know many people in life that would be able to go through what she was put through and come out the other side, and she did. So I do this for her, and I do it for all the other um, little boys and girls and parents. So with that, please leave your messages, comments, and your like or dislike is fine, please. And please subscribe so I know that somebody cares. At least 27 of you or whatever is cared enough to do it. And thank you from the bottom of my heart. I know several of you I know personally. Um, one last thing. I just thought about this. Defamation per se. Right here. Okay. What is defamation per se? Well, everybody knows what defamation is, relatively. Per se means on its face. If I tell who's somebody I can do that's dead. Oh my gosh. Damn. Jimmy Carter. We'll use Jimmy Carter. Oh, Jimmy Carter. Peanut King himself. If someone went on the air when he was alive and said, because they did this to President Trump, President Carter is a rapist. He raped this woman on what, and they make up the term, whatever. That's per se defamation, even as uh, a political and public figure. It's a lot harder to defend against the uh, yeah, I mean, stupid camera's not tilted right, and here I am leaning in the seat like I'm freaking hanging off of it. Nobody can see me. I freaking typical. Uh, uh, Defamation is usually against a public figure or a star or whatever you want to call it. You've got to prove malice, otherwise you're not winning. That's why Johnny Depp's case was such a big deal. Uh, thank God he won, because you talk about a guy who got screwed. He did. And Disney should. I'd tell them people to go to hell for as long as I lived. I would never go back to work for those assholes. They can suck it, along with everybody else that thought he was that what that woman said, because she is borderline and a nutso. Anyway, this is defamation per se. They're claiming that because they made false and defamatory statements of the fact concerning Baldwin, all they did was say what happened and what they thought was probable cause, y'all. That's it. That's all they said. They didn't come out and say he is a murderer. I don't think. They didn't come out and say he did, like, he raped and murdered her. He didn't do any of that. They didn't do any of that. They didn't say he purposely did it. That he purposely pulled the trigger, but with malice aforethought. I put the bullet. He put the bullet in there. We think he put the bullet in there and he pulled the trigger and killed her because he didn't like her, and whatever theory they come up with. That's not what happened. That's not what happened. They just made probable cause. That's it. And they think they're going to get defamation per se? Oops. No. No. I'd be surprised. I'd be really surprised if they get it. They're not going to get it. I don't think. It'll be interesting if this case goes to trial. I'd be shocked if this don't go out on summary judgment. Or hell, it may even go out on eventually. I'm going to go through the rules of procedure and rules of evidence. I think evidence probably be more interesting, but this is going to be probably Rule 12b1, Rule 12b2, maybe 3, definitely a 6 dismissal motion by the state. Not to mention, it's going to rely completely on the fact they pled the wrong laws. Luckily, at the very end, in that one little paragraph, they cite the New Mexico civil rights law. That's it. That's all. And that may be enough to dismiss the first two U.S. cited laws as the basis of their suit. And the court in a lot of states will allow the court to modify. They probably wouldn't or shouldn't, because the damn expensive lawyers are supposed to have written this. But if it was like a pro se defendant or plaintiff, they could, like Alabama's rule is basically anything that's written to the court can be taken as a pleading and can be modified. It's not a big deal. Courts can do it. So I don't know. If I was the judge, I'd probably boot it, being honest. Except for the one on the spoliation. That's a little bit of an issue. I have a problem with that. I have a big issue because I had a case with a Brady issue that I still think they were malicious about, and they screwed it. The guy got convicted. It happens. There's not a whole lot you can do. Turn the criminal case over to civil, for appellate people, and then get a civil lawyer and hope they can get something done. So, and they also sue for false and defamatory statements. And again, they were not false. I don't think they were false and defamatory. I just don't. Yeah, here we go. They talk about on CNN with the reporter, key pieces of evidence with the reporter from the Santa Fe, New Mexican. During the program, they asserted Baldwin had a duty to make sure the set was safe and should have checked that gun and those projectiles. Yes, he did have a duty. It doesn't mean that he committed first-degree murder, you dumbass lawyers. And these assholes, I guarantee these asshats make $700 to $1,000 an hour. The most, let's see, when I went from that to doing, I'm not going to say what I did, but I think the most I was charging was $250 an hour on average, because of the area I worked. Most people couldn't afford that, and I was running at about $150 with about 40 hours a year pro bono. I'm not a businessman. It's not. I mean, I'm just not. Excuse me. I'm just not a businessman. Bleeding heart, I guess. I'm not as much as I used to be, but yeah, it still hurts when somebody comes and says, I can't afford it. I can't even afford to feed my family and I need help. What are you supposed to do? You can't say no. Um, these people went apparently on Judge Janine's saying it was not a safe set. Clearly, it was not a safe set. This isn't going to work. None of this. They repeatedly stated that he was facing multiple years in prison if convicted on the charges. The maximum sentence was 18 months. Yes, but they thought they could do it the way they did it, even though they couldn't. That's still not malice. This is just him being a narcissist. I'm sorry. Now, this would be cool and okay to do. He filed a motion to disqualify that one lady, the prosecutor, on separation of powers principles. Probably should have been done. And she went in to say him and his lawyers used whatever tactics they want to distract from the fact that Elena Hutchins died because of gross negligence and reckless disregard for the safety on the set. There is nothing in those comments that's malice or even incorrect. They're not. So we'll go over that. Please hit like and subscribe. I hope you've enjoyed going over this. Damn, 2 hours. Oh my God. I totally blew this. Oh my God. I went an hour over. Dude, I'm telling y'all, man, the last one I did, it was my best ever video. Nobody heard it. It sucks. But, at least I got to talk to you about why I do this. It's kind of important, I think. All right. Thanks, guys. I appreciate you joining me. My name's Chris with Bama Law. Signing out. Check y'all later. Roll Tide.